Hey, folks, it's the end of 2012. We're going to look back. We're going to look at the disasters and debacles and the biggest legal news of 2012 and try and give you some practical advice about what not to do. We've got excellent folks joining us to share their insights with you. Professor Eric Goldman from Santa Clara University, Nilay Patel from The Verge, Evan Brown, and me. Don't miss it. Coming up next.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Evan Brown and Denise Howell, episode 192, recorded December 21st, 2012. What not to do in a box. This episode of This Week in Law is brought to you by ShareFile. Enhance your workflow. Send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a free 30-day trial, go to sharefile.com, click the radio microphone, and enter Twill. Ho, 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 folks. You've joined us for This Week in Law, our final episode of 2012, and it is going to be an epic episode. We've got fantastic folks joining us today. We've got Nilay Patel from The Verge. Hello, Nilay.
Hey, guys. How's it going?
Going great. Wonderful to have you. We've got Professor Eric Goldman here. Hello, Professor Goldman.
Hello, Denise.
Great to see you. Evan Brown is here as well. Hello, Evan.
Hey, Denise. Happy holidays. Hope it's not the last time we're talking to each other. You know, it's December 21st, 2012. The world's supposed to end today, but sure hope not.
So far, so good. As far as I know, other time zones have made it well through the day. So I think we're in good shape.
Here. We're all here.
Knock wood. If anything happens during the show, you guys, I guess, will know. We've got sort of a different twist to our show today for the year end. We're going to look back at 2012. You know, here at the end, it's our last show of the year. And we're going to try, whether you are perhaps a lawyer for a technology company, whether you work for a technology company, or whether you're just someone who uses technology such as web services, mobile phones, computers, whatever you can think of. We think we've got something for you of practical use in this show. And that's why our theme of the show today is what not to do. We are. I've mentioned the show "What Not to Wear" on the show before. If you've never seen it before, the BBC version is the definitive one with Trini and Susanna. Over here across the pond, we have our own version on E! Entertainment Television. And what they do is they go through people's closets, people who have maybe accumulated some things that they're comfortable with, but just aren't working for them anymore. You know, that big old boxy sweatshirt that's just not flattering. It's not presenting a good image, best foot forward, anything like that. So that's what we're going to do, looking at the legal decisions and debacles of 2012. We're going to go through your virtual closet and throw some stuff out because there are some courses of action that people seem to be taking that just aren't working for them at all. One thing that has happened just this week is an example of how not to update your terms of service. And Instagram has been the central player in this particular drama. I know that it's a big deal when folks on Facebook, who are my Facebook friends, who have never, paid attention to terms of service in their lives and are not technology world insiders or followers at all, are posting that they are going to flee and run and stop using the service that is near and dear to their hearts because they have learned that a terms of service update is going to include something that they're not very happy about. And maybe what they're learning just for the first time is that terms of service haven't been very advantageous for users all along.
Yeah.
But they're just finally figuring that out because somebody has highlighted a provision that is somewhat problematic. Nilay, you have been extraordinarily vocal and wonderfully explanatory on this topic this week. As things stand today, I don't believe Instagram has actually rolled out its new proposed terms of service, but they have stated in a blog post that the proposed terms that they were going to put into effect on January 16th are going to be changed in response to the user uproar this week. So why don't you recap what's happened for us, Nilay, and tell folks out there, whether they're working for companies or using these services, what they shouldn't do.
Oh, yeah, absolutely. So Instagram, they launched as a startup in 2010. They had an extraordinarily broad terms of service, which most startups have, because startups tend to pivot and change their products, and they need a lot of flexibility. So especially if you're taking a lot of user data, you need to ask for a lot of permissions. So the Instagram terms of service was extraordinarily broad, but broad in the sense that it tracked Google and Apple and Microsoft and Twitter and all these other companies. YouTube, I think, is a good example. They allowed to add to, delete from, modify, copy, use, translate, all laundry list of copyright license permissions for your content, and it allowed them to broadcast it anywhere in the world through any form of media. So this hugely broad provision. And then the second provision was also we're going to have advertising, and we can put ads, I think it's on, in, or in conjunction with your content. I want to your content pretty much, and they can put ads on your content. And that's the provision that exists today. Earlier this week, they said we're changing our terms of service. We've been purchased by Facebook. We need to change some of our data sharing provisions to allow us to share up to Facebook, which is our parent company, and to any of our affiliates. They changed the broad license provision. They added the words transferable and sublicensable, which freaked people out. They particularly changed, but they got rid of a bunch of stuff. So they got rid of the modify, add to, delete from, and they collapsed that all down to you agree that we can use your photos, which is great. I mean, they're limiting their license. So that's a win. And then the thing people really freaked out about was the next clause, which said, by the way, and you know that we're going to run ads, and to help us run more interesting ads, you agree that we can display, which is a loaded legal term, we can display your photos and user data and other stuff in conjunction or in connection with advertising and other paid promotions. So this somehow got completely misinterpreted to be Instagram can sell your photos. I don't know how or when that happened. It is very confusing to me because, to me, I read this as they had this broad permissive license to do almost anything. Actually limited the scope. So they went from we can do almost anything we want to your photos to we can use your photos to run our service, which everybody needs to be able to do, and we can display your photos in connection.
And then there were subtitles.
Right. So, huh? Say that again?
Your Skype dropped out a bit there.
Oh, am I back? I'm sorry. I'm just ranting. I can stop.
That's okay. Keep ranting.
No, but under the Copyright Act, display is an exclusive right, so it has a meaning. And I think people misunderstood display to, they can sell a photo. They understood the colloquial use of the term and not the legal term. And there was this huge backlash. So then late last night, Instagram said, okay, well, we'll display your photos in connection with advertising language, and we'll just use the old provision. And the old provision is we can put ads on your photos. And it's like they just spun it in. And I think it's actually really dangerous. I think there's the what not to do here is if you're going to change the terms of service, particularly around what you're going to do with user data, even if you think you have to spell out exactly what you're going to do in plain sense English and leave the the legal interpretation here is the support for what we're promising you users in a blog post or a press release or something. And their mistake was they changed their whole terms of service. They messaged, we're sharing data with Facebook, and forgot to message, by the way, we're also limiting our license to your content. And we're doing it in a way that allows us to show this exact kind of ad. And they totally lost control of this message. I think they were blindsided by it. And it's the fault. I mean, it's their fault in a big way, and it's the fault of the media for not really understanding how to read a terms of service agreement.
Well, the media is not alone in that, right? I mean, I think you've been mentioning all along that there are words in these particular clauses that could be interpreted a number of ways, and that's problematic. Professor Goldman, do you think it's possible to write terms governing the kind of activities that Instagram or any other company wants to be able to do with photos and other user-submitted data in a way that's clear and concise and actually says what they can and cannot do? Or are we stuck in this world where terms are always going to be broader than they need to be, and we have some, extrinsic position, as Nilay was pointing out, we've got a press release or we've got a blog post or some sort of promise that this is what we think these terms mean?
Anything is possible. Whether we'll see it frequently, I think, is less clear for two reasons. One, when lawyers draft the agreement, they want to check off the legal boxes. So, as Nilay indicated, they may want to use the word display, not for its lay sense, but for its legal sense, as one of the rights under copyright law. So when the lawyers use the terms in their technical meaning, it becomes very hard for people to appreciate that technical meaning unless they're aware of it. But I think more importantly, the document shouldn't be simply a legal document. It really is a document communicating with the community. And so it is possible, I think, to communicate with your community. I thought that the blog posts that followed trying to explain the Instagram situation were very honest. That's the kind of thing that users want from their user agreements. Be honest with us. I think what really went wrong for Instagram is that they were contemplating a bunch of different futures, but they weren't being specific about which one they might want to embrace. And so in their blog post, they later said, we're actually going to come back to you once we figured out what we really mean. That's great. If you don't actually describe exactly what you mean and embrace that, then no, of course you're going to have ambiguous documents because they're contemplating a future that the service provider doesn't even know exactly what it looks like.
One of the things that you've suggested as what not to do over on your blog, Eric, is that they should really sandbox this with a limited group of users before they announce it to the public. Because if you just have the executive managerial staff and the lawyers looking at this language, you're not going to get the same kind of forecasting of the user response as you are if you release it to people and let them start picking it apart and looking at it from the user perspective. Is that right?
Yeah. So if you're a small startup, you're not going to run your user agreements through a focus group. You're scrapping to just get it out the door. But when you're part of the Facebook empire and tensions are high, the rules are just different. You don't get to cut and paste and release and pray. You need to do your homework in advance. And so Instagram may still think of itself as a scrappy startup, but now that they're part of the Facebook empire, they're not. They're wrong. And if they don't behave accordingly, they're going to get what they get, like what happened now. I always, in my advertising law class, I always ask the students after we see an advertisement, usually a television commercial, I ask them what they thought of it. I just open up the discussion with a broad question. And consistently at the end of the semester, the students tell me that was the most revealing part of the class, that students watching that ad copy took away one message, and then they hear their peers who took away completely different messages, angles that they never thought. And I drive home the point with the students. You cannot intuit how people will interpret or misinterpret your ad copy. And I go the same premise holds for your user disclosure documents as well.
Nilay, do you think this was a failure of users to read and know the terms that were effective all along, or was this a failure of the media to accurately report what the January 16th changes were going to entail?
I don't think you can blame consumers for not reading contracts correctly. I mean, the history of consumer protection law is how big should the font size in your rental car agreement be, and that hasn't fixed anything. And you can't force consumers to read and understand anything, as Professor Goldman is saying. I think it's exactly right. Somebody sent me some survey data this week that said only 5% of users trust Facebook to do the right thing, which is like bonkers.
Who are those 5%?
Yeah, they're crazy, right? I mean, like, who are these people? My instinct is to say that Facebook has become a government and an economy unto itself, right? They're a country. They're as big as some countries. There are that many people in it, and the decisions they make. And the way people react to it are much. If you just look at it from a really broad, 30,000 foot, the way people react to Facebook's top-down changes is the way people react to our government doing anything, right? They don't want to participate. Facebook says, vote on our terms of service changes. And they're like, no, and they don't do it. And then they roll them out, and they're like, they freak out, and they start protesting and saying they're going to leave. And that reminds me of what happens when our government does things. And I think Facebook needs to understand that when they have that many users and they have that many people who are passionately interested in how their value is being used, and their value is their personal data on Facebook. It's the currency of that economy. That they have to tread very carefully, and they have to message exactly. You can't say we changed our legal document, go read it and figure it out. That's a road to disaster. They have to say, here's how we're going to advertise. Here's how we're going to take all of your social interactions and your life, which is what we want from you, and we're going to make money from it. And here are the things we are going to do. Instagram has to say, we're not going to sell your photos to Coke for a billboard, but we're already telling Lipton Brisk Tea that they can pay for the Brisk hashtag and promote it as a way to get user engagement with the brand. And I think if they would tell those stories and be specific about how they want to make money, we would never actually look at the legal documents. I think maybe this group of people would, and we would hold them to account on a legal basis. But the way people actually want to hold these people to account, or these companies to account, is on what they do. And they're doing a very bad job of saying what they're going to do to make money. And in Facebook's case, it's particularly worse, right? Because their revenue from the desktop is falling. They don't know how to monetize mobile. They're looking for additional revenue streams. They're iterating and experimenting rapidly. So they have all of this power and all of this control, and they seem like they don't know how to use it. And I think that's, for them, that's the danger for that company.
Eric, do you think it's realistic for companies to provide that degree of transparency into their strategic monetization plans?
Companies like to hold their cards close to the vest, not only for competitive reasons, because often they don't really know what they're going to do in the future, and they want to reserve all rights. But in the cloud era, where we have to trust these service providers enough to hand over very valuable resources of ours, our data, or to rely upon them for critical functionality that we need, I don't really see any other option nowadays. I think that businesses that want to engender trust will put all the cards on the table, will explain to their users exactly what they hope to do, and then they won't vitiate that trust going forward. They'll make the point clear enough for users to trust them, and then they'll continue to win that trust with every interaction. I don't see any other future, frankly. I think that otherwise we're just going to get what we have today, these serial failures of cloud providers to understand what we as users want, and then us migrating from cloud service to cloud service, saying, well, okay, Instagram didn't work. Let me go try next free video photo hosting service that's going to turn on us next. I mean, there's no winning that game until some business says, okay, here's what I'm going to do, and here's what I'm not going to do, and I'm going to lock myself in so tightly that you can trust I'm actually going to deliver on the promises I make to you.
Well, so let me ask you that. I mean, to me, what you're describing is winning that game of users are going to bounce from service to service until the market responds with the service they want. You can share your photos and we respect your privacy. But what I worry about is that there isn't actually that market for privacy, that there are these fake outrages over Facebook. There are these hoax paste these magic words on your Facebook wall, and now they can't advertise to you. Let's have an uproar about Instagram, and maybe 5% of power users leave, and then everybody filters back because that's where the people are. I worry that there isn't a market for privacy in that way, that there won't be an incentive for any one of these companies to actually make a meaningful change to their terms of service. And I look at that at the biggest level. I mean, if you compare Dropbox and Google Drive and iCloud and SkyDrive from Microsoft, their terms of service, they're vague. They say they can do all kinds of insane things. I mean, I think it's Apple that just says we reserve the right to delete objectionable content from iCloud, which could, as far as I can tell, ranges all the way into iMessage. It's the same terms of service, and there's no definition of objectionable. It's just there, and there, that's Apple. The 5% of people trust Facebook to do the right thing. Lots of people trust Apple to do the right thing, and I read that, I'm thinking that doesn't even pass the sniff test of what I want a cloud service provider to do. But the market hasn't demanded Apple make any changes at all.
A couple of points about that, although I think they're great. Point number one is that I don't know that I really care what the contract says. I care what the business does in practice. So if the lawyers feel more confident putting in the weasel words that they could go and do ridiculous things in ridiculous circumstances, and then they never do, and they can convince me they're never going to do that, I don't know that I really care that the weasel words are there. But to your point about the market responding, I would put Facebook in its own category. Facebook has other ways that it can control users and lock them in than, say, a photo hosting site, which might have a deep reservoir of user content, but assuming that user content is transportable, they don't have necessarily the other hooks that keep users from migrating to a competitive service. So I think that there is the capacity both for users to move from place to place in most cloud services, and they will do so if the cloud service can't win their trust.
Eli, getting to your point about whether there's a market for respect for the users, James Wallace over on Twitter put up a funny status that caught my eye. He says he's comparing apples and oranges, these terms of service changes to file sharing, but he struck a nerve. File sharing, you don't mind when it's some musician's song or designer's game. When it's your Instagram photos, it all changes, huh? The point that he's making there is and I think it's another big lesson to take away from this is people are starting to recognize as this ecosystem evolves and they continue putting their own data into these services as, the fuel like Monsters screams in Monsters, Inc., that they are producers and that the rights to their own, whether you want to call it privacy, whether they have any monetization designs, probably not, but they know that these are their own works. It's their own property, and it matters to them. And I think we're seeing that in the fallout.
I saw a really interesting comment. I don't remember if it was on TechDirt or Grok Law. But it's just a commenter. It has no reflection on his sites. I read. But one of the commenters was like, in response to Instagram, said, what the problem here is copyright to begin with. We need to abolish copyright. And I'm sitting there thinking to myself, that is just about as completely wrong in this situation as you can get. I mean, if you didn't have copyright in your photos, they could definitely put them in ads. That's the thing you don't want. And I think there's a disconnect, and it's not a disconnect between respecting others' work versus respecting your own. It's a disconnect between how we want things to be exploited. So copyright, people don't understand that copyright protects them as well, right? They don't make the connection between I took this photo and now I have a copyright and now other people can't infringe my exclusive rights to this photo. That makes no sense to them. And that's why you can say something insane in a headline like Instagram can sell your photos. What does that mean? When I was that doesn't mean anything. Can they sell a copy of your photo? Can they license it to be in a television commercial? I don't know the answer to that question. That word has so much inherent legal meaning that you have to unpack it very carefully. But they don't know that. And they don't make that connection between I have copyrights, I'm creating economic value in some way by creating content, even just on Facebook by typing in a comment, and somebody can take that away from me. What they do know is that the huge corporations scream in their face that they're being destroyed by copyright law all the time, and all they're doing is listening to music. And that disconnect is like really important. I think that services like Instagram and in some cases Facebook, but services like Instagram and YouTube and Flickr that really reward user content are beginning to educate a generation of consumers what copyright should mean to them, what it should mean in this society, and how we should value one another's contributions. And that is slow going. It won't be fast. And I think this Instagram thing, if you asked anybody, Instagram can sell your photos, is that a copyright issue? I'm pretty much willing to bet they would be like, no, I have no idea what you're talking about. Instagram shouldn't sell my photos. And the disconnect is real,
Right. Well, there is a continuum here in these photo sharing services. Probably most of them don't actually want to sell your photos in the conventional sense where, money is exchanged and rights to a photo are transferred. Of course, as you're pointing out, Nilay, they're selling your photos every time they're making money off the advertising on their sites. But in some instances, they really do want to sell your photos. Professor Goldman, can you bring us up to speed with what's going on with TWiT? That litigation is still pending, correct?
Yes, it is. And I must confess, my co-blogger, Venkat, has been our expert on the topic. So I'm not 100% clear what the latest status is. But the overall issue is, I think, as Nilay was pointing out, somebody misread the user agreement in a very gross way and thought that the language in that enabled a photo to be pulled off of TWiT for publication without paying. And I don't know how they got that conclusion, and I think they're going to pay for that.
Mm-hmm. But I think it's pretty clear after TWiT's terms of service update, and I'm not sure if that was earlier this year or in 2011, but they pretty famously changed their business model to say, yes, we can sell your photos, and we will. And you can go elsewhere if you don't like it. So you've got, and if I'm wrong about that, again, I have not reviewed that in a while, so I don't want to slander the company if their terms of service have changed or if I am interpreting them the wrong way. But I definitely encourage you guys to look at, there's some great articles out there, for example, on Ars Technica comparing the various services that are out there and what each one of them purports to be able to do with your photos. So, it's an issue to pay attention to as a user for sure, because some want to keep their doors open for business plans to manifest in the future. Some actually have some very aggressive business plans that they are implementing right now. And you should be able to at least begin to glean that from the terms
Well, this
themselves.
is really interesting. So I'm looking at the terms of TWiT. This is kind of bonkers. To publish another TWiT user's content for any commercial purpose or distribution beyond a Twitter retweet, you are required to obtain permission from TWiT and credit TWiT to this as the source where you've obtained the content. What? Why?
Because
Why
I
do
guess
I have to do that?
they have obtained that broad a license from their users, or so they think. That it's.
I mean, right, but it's a non-exclusive license. I mean, you could just ask me. You can do everybody. You can republish my TWiT pics. Please go ahead. Why are they stepping in the middle of that relationship?
Yeah.
I mean, this is the sort of thing where it's, I've been using TWiT for years. I never looked at this. I should have been watching this show more closely, apparently.
Nilay, don't you think, if anything, that provision in the TWiT terms of service there is to actually keep users happy so that other users aren't being renegade with the photos? If you think about how a dispute like that would actually play out, if a user saw that his images were being used by someone else, there might be some dispute or some litigation between that. And I don't think TWiT would actually intervene in that lawsuit saying, hey, you also have violated the right, you breached this covenant here that's in these terms of service. So it goes back to Professor Goldman's point. what really is going to happen and how the platform is going to enforce it or choose not to enforce it is what's going to carry the day here. This is something that I would suggest in the TWiT terms of service is just to keep users happy, so that there is actually some semblance of control over what others can use with the images. Do you? I mean,
I agree.
Am I coming from ours?
I agree with you on the motivation. I think my bigger question is, have we just completely gone beyond the ability of these kinds of contracts to govern anything that we do online? I mean, Professor Goldman is saying, well, it doesn't matter what rights they take from users. It matters what they actually do. And if you will sign that contract with me, Professor, I will happily draft you some language and have you sign it right now, and I'll take your house. And I'll promise that you can live in it. If we're not holding,
I have to win my trust before I sign that contract with you. Obviously, that's part of the point.
Right.
I'm not sure you won't trust over yet.
Right. Well, I'm pushing the worst example, obviously, but how do you write a contract that for a startup? And I think this is with Instagram, it's particularly important because they were a startup and now they're part of this big company and actually more careful, but they have this startup mentality, and TWiT is the same. How do you write a contract, a terms of service for a company that doesn't know what it wants to be when it grows up, but needs broad license to operate and figure it out, that also respects users' rights, that also defines clearly what's going to happen, and on top of all of that is expected to mutate as the service itself changes? Is that even a contract anymore? I'm not arguing that these things aren't enforceable. I'm arguing that don't we need some other kind of vehicle that actually understands the internet beyond
what do you suggest?
Words on paper? I don't know. That's why I write for a living. I don't write the laws. I just write the blogs, dude.
I hear, but it just seems at best you would have another form of contract, because contract is the animal that we're talking about here to talk about the legal rights and obligations between people. Are you talking about it's a totally different animal, or just that the contracts need to say something different?
Yeah, don't we need to create another form of contract that understands that not only is the company rapidly iterating, not only is one party rapidly iterating on what the business model is for the use of the data, but the user norms and society perception of what is acceptable is equally iterating, and the contract itself might change from 1 month to another. So the contract I had with Instagram yesterday is not the contract I'm going to have with Instagram on January 16th. But I gave them the data under the previous contract. And it seems to me that these terms of service it's like we've pushed well beyond what they can do within the boundaries of the existing contract law. Maybe I'm wrong. That's what that feels like to me.
Well, one solution Facebook tried and then abandoned was to put all these kinds of policy sweeping kind of changes to a user vote before making them starting back in 2009. But this year, they decided they are not going to be a democracy. And Professor Goldman, you think that was the right decision. So there's a kind of a difference here. Focus group, yes. Democracy, no. Can you explain?
Well, there's a couple of different moving parts there. We want our service providers to respond to our interests as users. But putting them to a user vote is probably not the way to do it for a couple of reasons. One, not many users are going to vote, period, for some of the reasons we've already discussed. And two, is that I don't want to invest the time to try and figure out how the site should be run. I want the site to just work. I want it to be a turnkey solution for me. Just like how I want my car to start in the morning when I put the key in. I don't want to have to make a bunch of choices about the policies that govern my use of this valuable resource. The idea that Facebook was going to get users to actively help manage the site was, I think, always farcical. Now, certainly bringing users into the decision-making process can help. And the examples I'd give are where sites designate the equivalent of like a board leader or some kind of a section leader, where you've got a user who is not a company employee, is from the community, is going to manage or run a piece of the site. That sounds great. That's not a democracy. There's certainly no voting mechanism to that, but it's still a way of letting the users help shape the way that the site works. But
it's
what
more
users
like,
want,
feudalism.
well, perhaps. I don't know if we need a label for it, or maybe it's something new and different that we haven't seen before. And it could be paid. And frankly, many community members will voluntarily take on additional responsibilities for a website and not want payment whatsoever. They're happy to do it for some other payoff. It might build their reputation and they'll commercialize another way. It might be that this is just their hobby. They do it for fun. When we talk about feudalism, we might talk about some kind of hierarchical relationship that we don't want. But I think that undersells or maligns the fact many users want that power and value that power, even if they don't get paid to exercise it. Sorry,
well,
go ahead, Evan. Go ahead, Evan.
Whenever I hear talk like this of like deputizing users, like community managers or something like that, I think of the question of whether or not they then become agents of the site, especially if they're getting paid. You would think that you could make a good argument for that. And our pattern and our habit is when we have you on the show, Eric, we've always got to talk about Section 230. That seems like a decision on the part of a platform to give power to its users, really deputizing them, making them agents of the platform. It seems like then that runs a great risk, or it makes the site run a great risk of losing Section 230 immunity, because then what those moderators do, the original content that they come up with, isn't content that's provided by a third party anymore. So I guess one of the questions to discuss on this is, if that analysis is true, if that would start carving away, paring back at Section 230 immunity, is that a risk worth taking? Is that an economic gamble worth taking, or an economic proposition that would pay off in the end to solve this one problem, just to give rise to another one?
We've seen a few cases on this very point about whether community leaders, board leaders, moderators are agents for purposes of Section 230 analysis. And I wouldn't suggest that this law is clean. I think that judges could be easily swayed. But certainly creating an agency relationship is something more than an independent contractor relationship. And so my normal starting point is that these are independent contractors. You have to do a lot to create an agency relationship. And usually that's not the case at all. And frankly, it's not even close unless somebody wants to make mischief. So we've seen a number of cases where Section 230 has applied to the acts of the board leaders, moderators, et cetera, even in the face of an agency challenge like the one that you just described. But let me just close the thought for a moment, just with what we really want from Facebook. I don't want to vote about Facebook's policies. What I really want is the configuration options to decide which of their policies I like and which ones I don't. And the example I'll give here, but we could pick many, is a timeline. I don't care if Facebook rolls out timeline, just don't put me on timeline, because timeline is horrible. And I want to put that to majority vote and say, okay, majority, do you like timeline or not? And if the majority votes yes, I still don't want it. So rather than having the majority will, or even a user vote, what I really want is the ability to have the customization, the personalization that lets me choose which policies I like and which I don't. Not always realistic, but if Facebook really wants to empower its users, it has an option that's much better than a Mickey Mouse style voting system that was never going to work.
So there's another what not to do. Don't fail to provide customization for your users, what not to do, when you could easily use that to solve a problem. One thing that I've seen people tossing out there that I thought was an interesting twist, I don't think that they're right, is on the language in the proposed Instagram changed terms that are now going to change before we see them. That purports to be able to hide whether something is advertising. We reserve the right not to disclose or make clear to you that we're being commercially paid for some kind of content. I've seen people going, wait a minute now, the FTC came out and gave some guidelines on this. Those guidelines are for bloggers, and Facebook and Instagram are not that, although some might say the users on those services are using them in that way. Professor Goldman, do you have any thoughts on that aspect of this?
I saw that language and I read it and I read it over again and I thought about it and I thought about it some more and I still don't know what the heck it means.
I have no idea.
It's almost like a wish list. Like, we'd like the ability to do stealth advertising to you and have no legal consequence for that. And I don't know if that's something that you can do by contract. I don't know that you can simply say, we've now agreed that whether it's advertising or editorial content, you can't complain about how I presented it to you. I don't think that works. I don't know what they're going to do with that language. I don't know who's going to come and challenge their behavior, where they're going to trot out that language and say, see, I told you that I wasn't going to tell you. I don't really know what it means. My starting presumption, and we actually had a conversation among some people I trust in the law professor community about this language, and I think we all reached consensus that we don't think it really does anything. It's more like a wish list. Like, Santa, could you please give me a free pass from FTC scrutiny if I do stealth advertising? I think Santa's going to leave that sock empty.
Well, I think that, if you look at it, and I think it's funny that we have different perspectives on this, because when I write about this stuff, I write about it from the perspective of what the product might be. And from that vantage point, I see why they'd want to do it. Because if I'm Instagram and I'm trying to think of any way I can make money running the service, one easy way is to say to BMW, if you want an Instagram account, you have to pay us because you're a brand, and if you're not a person, you have to pay us to use the service. And BMW is going to say, that's great. Here's $1 million a year. We're going to use Instagram, and just like anybody else. And if I'm Instagram, I don't want to put sponsored content above every one of BMW's posts. And I don't think they should have to in that case. I think they can run a hybrid business model where they can say one class of users has to pay to use the service, and then another enormous class of users doesn't have to pay to use the service. And I think the brands are happy to participate. Yeah, I think Pinterest is they're working on that, right? I mean, that's one way that that's how Twitter uses. I think Twitter has promoted accounts, and they're good. They disclose that it's promoted because Twitter likes to think that they're the last bastion of free speech in the world, and that's great. I applaud them for that. But I really see why you would want to create contractually the expectation that not everything you see on the service is like some organic user thing, that some of the content might be paid for because we might charge brands to use the service. I don't think Instagram has any idea how they're going to make money. I think they wrote a terms of service that very specifically allowed them to repurpose photos so advertisers could buy. I think the example I gave on Twitter was they could buy the hashtag NYE, the New Year's Eve hashtag, and say 2013 sponsored by Coke, and then that search result page would have a Coke logo on it. And that's a perfect example of we might display your photos in connection with advertising. I think that's one idea they have. I think another idea they have is we're going to charge brands to use the service. And I think a third idea they have is, holy crap, we have to come up with another idea. And I think we're going to figure out, I think now they're under pressure to become a revenue stream for Facebook, and they're going to start pushing those ideas as fast as they can.
I think that's fine.
Sorry, go ahead, Eric.
Yeah, let me just
finish up your thought.
Yeah, so I think that's fine, but I still, if if Instagram's going to sell BMW an account, that's fine. But I don't know if the FTC or any other regulators are going to say, well, okay, you can ignore all of the other legal rules because you put it in the user agreement that there might be something going on that we haven't told you. So that's the part that I think is a disconnect. I don't know.
Well, wait, so let me ask you, what would the applicable rules there be? I mean, if they just say, if you are a company, you have to pay us, and if you're a person, you don't. Does that start to trigger FTC advertising regulations?
I don't know. My point is, I don't know if putting it into a user agreement helps address that problem whatsoever. In other words, I think we have to look at that question on its own terms. I actually don't know the answer to that question, and it's something I haven't researched. And so, I'm not disputing your starting point. It's possible that they wouldn't need to make that disclosure. My point is, I don't think the user agreement is the way to fix that problem. I think you got to deal with the law on its own terms, and I don't think that kind of ambiguous, murky, maybe possibility disclosure is going to do anything helpful legally.
All right. Well, we've already gleaned so much of what not to do out of this Instagram story. I bet you think we're done, but we're not, because there's one final point that leads us into another discussion of what not to do, and that is the fact that still in the proposed changes that were rolled out was language purporting to have the terms update without any further notice to users. Now, on this show and extensively on Professor Goldman's technology and marketing blog earlier this year, there has been much discussion of the Zappos decision, which basically tossed out the window the notion that you could have in terms of service for any site this provision that, you know what? Just by coming along and reading these terms, you're agreeing that we can update these terms at any time, and they're going to apply to you ad infinitum. Like you were talking about, Nilay, terms change, and so you're agreeing now that as they change, you're going to be governed by every iteration of them going forward. Courts don't like that. The Zappos court didn't like it at all. And so as for what not to do, don't think that a browse wrap document like that is a contract. As Professor Goldman calls it, it's not browse wrap. It's not a contract. Go ahead. So
here's an interesting. I had a conversation with a super large service provider a few weeks ago, and I was like, "Are these contracts even enforceable?" And he laughed at me, and he was like, "Look, it's not only in our best interest that it's enforceable. They're in the FTC's best interest that we hold these contracts enforceable, because the FTC can come up to us and say, you promised your users you weren't going to do this, and then you did it. Here's a fine and 10 years of auditing." And the FTC is very active now in making sure that browse wrap agreements are at least presumptively held valid. Maybe that they'll fail on technical contract challenges, but at least presumptively held valid, so that they can try to enforce them. And that's what I'm saying. Like, is this the right vehicle? Are we trying to staple the internet onto 5 centuries of contract law or whatever it is? I don't know if we're at the right place. The balance is shifting so rapidly that I worry that our ideas about how a contract should mutate over the lifetime of a service and of a society are not in line with what contract law actually says.
Well, I totally agree with you, because Professor Goldman, can you outline for us what Instagram or anybody else, Zappos, needs to do what not to do is to say you agree to all the changes. What do they need to do?
Well, first of all, just to address Nilay's point for a moment, I think we're talking a little bit about apples and oranges again. As a matter of contract law, there's rules and regulations about how to implement a contract properly. But the FTC doesn't care whether a site disclosure is a contract or not. If the site disclosure is made and users rely upon it, they don't care if it's called a contract, if it's called marketing. It's binding on the person who makes a statement in a variety of different legal doctrines. So I don't think the FTC wants to see user agreements as a contract. They are completely agnostic about that. that. They want any promises that the site makes to be binding, but that might not be a two-way street. It might only be a one-way representation. Now, to Denise, your question, and this is something that I think is ripe for further discussion, and I don't really have a clean single answer to the question. How can websites amend their contract? Now, under contract law, we're putting the whole false advertising piece to the side. How can they amend a contract over time? There's one thing we know works, which is to require everyone to agree through proper contract formation processes to the amendment. So, for example, you could require users to click through the amendment just like they should be expected to click through the initial agreement. Most sites don't want to do this. I'm happy to discuss why. It's not really feasible. It's clear that if the user agreement is amended and no notice is provided to users individually, that fails. And we have a Ninth Circuit case saying that specific point. So there might be some compromise where users are given notice of the amended terms and ideally some kind of way to take recourse if they disagree with them. And that might work as something less than doing a full click-through amendment, but more than what some sites, including Instagram, still think they can do. They can just post on the website and let users hopefully figure it out. We know that does not work.
Let me ask you a question. I just want to push back on the contract formation thing with the FTC. My sense of it is that it's stronger for the FTC to say this is a contract rather than a one-way representation, some sort of false advertising claim. I mean, I don't think the FTC wants to lose that avenue of attack for a Facebook or a Twitter. Both companies that they have gone after and they are auditing in some way. I mean, why would you want to lose, if you're the FTC, why would you want to lose what is arguably your stronger weapon in favor of saying it doesn't matter what weapon we use?
I'm not sure I understand your question. The FTC isn't likely to bring a breach of contract claim because they're not a party to a contract. They will enforce their authority against deceptive and unfair trade practices. So they're looking for deceptive trade practices, and those can be done within the scope of a contract where both parties are bilaterally obligated. But a deceptive trade practice can be making a promise outside of a contract and where the other side isn't bound whatsoever. So the FTC doesn't care whether something's called a contract or not. They're looking for deception. They also use their unfair authority, but let's just ignore that for a moment. They do it in a really bizarre way. Let's just focus on deception. It is deceptive to make a false marketing representation. It's deceptive to make a false promise in a contract, and either one is fair game for the FTC.
I would suggest it doesn't even have. I would suggest it doesn't even have to be in a contract either. I mean, you see the FTC taking action on privacy policies as well, and I think it's certainly unclear in a lot of situations where a website privacy policy or a mobile app privacy policy forms a contract between the user and the provider, unless it expressly says so. I think a lot of service providers would argue that a privacy policy is not a contract, but the FTC still takes actions on those as well.
So let me ask you. And I'm learning as much about this as anything. I was a copyright attorney, for God's sake. Is the FCC the only authority here? I mean, it does. I mean, the Instagram terms of service require it to go to arbitration, right? You can't do a class action, and I don't think any individual user is going to sue Instagram for infringing their copyright in some bizarre way. Is the FTC the only real authority here? Is that actually the answer for these companies to take their policies and get them certified in some way by a federal authority? Or is there some other answer? I'm actually very curious.
When it comes to marketing representations, and those can be in the scope of a user agreement, or they can be in language that's outside the scope of a user agreement, we worry about multiple different enforcement agencies or authorities. We worry about the FTC at the federal level. There may be other regulators in particular industries, such as the Consumer Financial Protection Bureau if you're in the financial industry, et cetera. We worry about the state attorney generals, and they love to feast on internet companies companies. Nothing makes them prouder than to hold up the severed head of an internet company and say, "We did this. We're proud of ourselves." We always worry about the class action lawyers. Class action lawyers are feasting on internet companies as well. And all they need to do is just track the venture capital reports. Who got money? Let's look at their site, see if we can find anything wrong, and let's go take that VC money and put it in our pocket. It's a great way of raising venture capital. And then we also worry about either competitor lawsuits or other competitive disputes, things like battles that take place in the NAD as a private adjudication forum. So when you're thinking about making a statement on a site, you got to run the gauntlet, not just what's the FTC going to think about it. Frankly, the FTC enforces probably 0.1% of all the problems they see. So they're usually actually at the end of the concerns risk-wise. You're worried about what the class action lawyers are going to do. You worry about what your competitors are going to say. And you worry about all these other enforcement agencies that have nothing to do but to sit around and say, who should I bust today?
So is that a market? I mean, that just brings me all the way back to, is there a market for privacy? I mean, that sounds like there are many market forces conspiring to drive positive outcomes. Would you say that's working well?
So I actually wouldn't call those market forces. I would call those legal in terrorem.
I was thinking you're talking about competitor lawsuits and competitor actions and competitor speech. That's where my mind went to, because I live in that world most of the time. I mean, is that effective?
Yeah, competitive enforcement actions are actually quite effective at keeping the rules of play clean in an industry, with one at least minimum huge exception, which is when everyone's doing the same practice, at which point then the entire industry is corrupt and you need somebody to come and bust them. But the other way it breaks down sometimes is when competitors don't care about the practice, but consumers care a lot. And sometimes there's a role for protecting the interests of consumers, and it's just not worth it to a company to enforce it against a broken promise against their competitor. So, but I come back, in the end, actually, I think market forces is the right term. The market forces are the principal driver of clean behavior in our economy. It's our responsibility as consumers to invest wisely with our dollars or other resources. And frankly, I think the response to Instagram is a good example about that. There are people who are going to take their marbles and they're going to go away from Instagram because they don't trust Instagram anymore. And that's true even if Instagram goes back to the old agreement and says, we didn't mean anything we said. We'll go back to the deal you signed up to. And they're still going to walk away because they don't trust them. And that's the marketplace working actually quite well. Competitors don't need to do that. The FTC, the state AGs don't need to do that. The private class action lawyers don't need to do that. That's the marketplace speaking. And as long as we can continue to look for ways to encourage that behavior, I actually think we get to good results.
Well, one of the things that Instagram and other companies who are having users submit their data and their lives as the bread and butter of the business they need to make sure that these contracts are valid, don't they, Professor Goldman? The FTC might not care, but Instagram cares if they've gotten that license. So we're back to Nilai's conundrum that online contracts and their changes and the way to make them legally enforceable don't add up to something that makes a whole lot of practical sense.
Yes, that part I do agree with, because I don't have a clean solution for how to continue to evolve a contract with an existing user base over time. And so without the ability to do that, it's not entirely clear to me how we achieve sensible results when services migrate and evolve. But you're absolutely right that it's crucial for the services to get properly formed contracts. And that's not just about the license provisions. It's about all the other things that are in the contract. It's things like the governing law, venue, and or arbitration. And arbitration can be used to suppress class action lawsuits. And so that's super critical. You want to be sued by class action lawyers? Never. And if you can use arbitration to squash it, That's as valuable as the license provision. You also want it for all the other risk management provisions, the disclaimer of warranties, the limitations of liabilities. There may be times that you're legally required to enter into a contract. There's a positive law that says you must have a user consent in order to do what you want to do. Licenses are only one example of that. So it's crucial that the contract formation piece gets handled properly. What I tell my students in my internet law class, I say 90% of the battle as an internet lawyer working on user agreements is the formation piece. The 10% will take care of itself about what you actually say in the contract. But if you miss the formation piece, who cares what's in the other 10%?
So do you tell them that they have to have a box pop up and the terms of the contract and there's a click and that's showing assent? Absolutely.
Mandatory non-leaky click-throughs. That's my personal jargon for it. It has to be mandatory. Users must go through it. It can't be leaky. There can't be ways for users to route around it. And it has to be a click-through. Those are state-of-the-art, accept no substitutes.
There you go. You heard it here. All right, Evan, any thoughts on this before we move off the wonderful world of terms of service?
I think it's all good. I think we've covered it well enough for 1 year.
There's certainly been a lot to cover.
It feels like it's been a year just talking about it.
Yeah.
Well, let's have a musical interlude then and move on to the entertainment arena. So our what not to do takeaway from the entertainment arena in 2012 is don't kill the golden goose. And the star of this show is Psy, the Gangnam Style guy who is the AP estimates by going through various publicly accessible materials and data that he's going to make over $8.1 million just off of YouTube ads, not on his own video per se, but on all the iterations of it that are out there kicking money back to him because he allows them to exist. This is maybe something that, the old sweatshirt in the closet would be, we're going to file DMCA takedowns every time someone's using the song, every time somebody's, doing anything vaguely related to the song. Time to throw that out because for Psy, it's definitely working for him. What do you think about this, Professor Goldman?
So I am one of the few people in the world who has not actually watched the video.
Wow. So you got to watch it. You should do it right now. You're missing out.
Yes.
I put it in the category of this is the 2012 Macarena, but maybe that's overly disparaging. But I mean, what a wonderful example of how people can create content that can generate enormous value without relying upon the old model of copyright, that you have to sell out physical chattel with the copyright item baked onto it in order to make money. And so we have so many examples of this. It's great to find a really high-profile one, but I don't want that to detract from the idea. You don't have to have a runaway hit like this video has been in order to replicate its success. So I think it's terrific. I think it's a great reminder of the power of the internet, the power of virality, and the fact that if people come up with differentiated content that's executed really well, there will be ways to cash in on that, and copyright may be among the worst ways to do so.
So I completely disagree with you, I have to say.
Okay.
I mean, just over half of his take, so he's made $8.1 million. Over half of that take, $4.6 million, is from commercial licensing deals, which rest upon the foundation of copyright law. The rest of it is he's running ads on YouTube, I guess, and he's selling iTunes downloads. iTunes downloads rest upon the foundation of copyright law. I mean, it's great that he's not persecuting fans for remixing his video, but what sane artist in 2012 is doing that? This stuff to me feels like we're attacking Lars Ulrich in 2012 for what he said in 1998. And it doesn't make any sense to me. I mean, I think the music industry completely understands that their biggest goal is to put the stuff on YouTube, and they get everybody to make YouTube covers of it so they can sell iTunes downloads and put the song in an Audi commercial. And to do that, to get to the next step, they have to have the artificial scarcity of copyright. They have to be able to say to Audi, if you want to use this song, you have to pay us. And they have the choice to not say to the University Marching Band, you have to license this. Although I'm pretty sure the University Marching Band is smart enough to get whatever they need. But they have to be able to say to the kid at home in the kitchen, you don't have to license this. And they've learned that lesson. It feels like we're hammering on this drum that you don't need copyright to do any of this stuff, but you do to make the money. Like, in the end of the day, the copyright law has to exist and be strong and protect you and protect Psy against the large commercial interests who want to do nothing more than take his work and misappropriate it.
I'm not saying I don't think our takeaway, our what not to do, is trash copyright law necessarily, but be selective about your enforcement of it. For sure. Going back to the marching band and other people
but
who might
isn't. Wait, but my question is, who isn't selective? In 2012, what mainstream artist isn't selective? That's what I'm. That's what I'm saying. It's a straw. Prince is Prince. I mean, like, Prince has been crazy for as long as he. Fine, Prince is in a box. Like,
I don't
he gets
know what
the
he
A's.
is.
It's cool.
He said Prince in a box. I'm not sure he's done anything in 2012, but I suppose if you ask him now, based on how he has been for the last 25 years, he's crazy in a box.
Right, but I'm saying there's a generation of artists that doesn't get it, and that's great. And let's let him go, man. I think Questlove wrote a really interesting piece. Did we talk about it in this show?
I don't think so.
When it came out, but Questlove wrote a really interesting piece that was basically how sad he is that he goes and DJs, and there's a generation of kids who don't know who Prince is because Prince has declined to be online. And that's heartbreaking for Questlove. It's heartbreaking for me. But the kids don't care. They've got Psy and Carly Rae Jepsen, and they've got their own and Lady Gaga. And they've got the people who are talking to them in the places they are and in the language they speak, and they're fine. And so I think arguing about what Prince should do, and not to pick on Prince, but arguing about you know what I'm saying, arguing about what Prince should do is like wrong. Like, whatever, let him die. That's fine.
There's plenty of examples of copyright trollish behavior to be found, though, outside of music. I mean, if you look at all the plaintiffs in the BitTorrent litigation, the porn companies and other companies, I mean, that's ridiculous. They're taking such a strict point on copyright law. They're not beginning to even in any remote way say, if we have more people trading this stuff on BitTorrent, people are actually going to buy more of it, which would be the same principle as what I'm saying here.
It's hard for me to step into the shoes of a pornography vendor, as much as I've tried in my life.
Next career change.
They've got unique problems, right? I mean, if you listen to the way they talk about those cases, like, nobody's going to make a remix of a porn video. The shelf life of their product is 5 minutes. They've got they have unique problems that the content they sell is not valued or respected by anybody externally to the copyright law. So if you're a porn producer and you say, please respect my moral rights to this content, people are just going to laugh at you. They're like, no, you make porn. So of course they're leaning on the law because it's the only thing that actually grants them leverage in the world. And I don't know.
Right,
what's the answer there?
I'm going to jump in so that I manage to get these into the show. We'll put our first MCLE passphrase in right here, and it's going to be Prince. So if you're watching the show for MCLE credit and you need to demonstrate that you have listened, your first word for that is Prince. And what I was hoping to do, too, since Professor Goldman has not yet seen any iteration of the 33,000-plus Gangnam Style videos out there.
No!
Not the original, but this one. And Nilay, it goes to your point about, you would think someone like the marching band would clear rights. Well, how about NASA? Have you seen Johnson Style?
Oh, my God. Why would you do this to me?
Did you sing a dance?
Johnson Space Center right here.
Johnson Style.
is Johnson Space Center. We are coming in hot, so don't burn up as we enter. We do science every day that affects your daily life. Throw them up for manned space flight.
All right, not going to infringe on Johnson's copyright too much by showing the whole thing, but it is wonderful. If you haven't seen it yet, it's a great promotion for NASA. My kids' school just loved it because they have just finished a whole space unit. They know all about Orion. They're pointing out, oh, I know what that is. I know what that is. So, very fun, very educational, great way to get people interested in what NASA's up to.
Denise, it's great to see good dancers among the rocket scientist crowd.
Exactly.
There's a really interesting. It's funny because they're using the actual backing track. And I don't remember. It was years and years ago, but there's an interesting case that if you publish the acapella to your song and the backing track for DJs to use in clubs, that you have somehow provided an implied license for them to create derivative works. People have gotten really savvy about this lately. I'm wondering, did he actually release it officially? And if he released it online, did he say go and do this stuff? Because that's very possible.
I think so. I think I remember reading that there was a. Let me, in fact, pull up that AP article because I think there was something in there. And you can look at all of the articles that we're looking at for the show at delicious.com/thisweekinlaw/192. Great AP article on. Size riches from Gangnam Style not made at home. They're focusing on.
I will
how most
say that
if
you look on Google for Gangnam Style acapella MP3, there are results that have been pulled because of the DMCA. So he's doing something.
Without reading through this whole article again, I think I saw something in here that yes, they did release one that is made for that purpose. But fact check me on that if you would. So I think this is just a delightful story, and I get what you're saying, Nilay, about for death eventually taking care of the people who don't already get this. But
it's a really terrible Steve Jobs quote, by the way. It's death is the best invention of life.
Yes. Well, I went to a conference where he was saying he was never going to do a tablet, and. In talking about the history of Apple and saying, well, people couldn't type, but we knew that death would eventually take care of that. So didn't slow down the company. Let us move on from Psy and talk about, well, first of all, let's take a break. We're here with Nilay Patel from The Verge, Eric Goldman from Santa Clara, and his own technology and marketing blog, which is just a definitive resource for all things related to tech and web law, and Evan Brown and me. And we're running down 2012, the latest and greatest developments and decisions and debacles of the year, and trying to let you know what not to do from what we can look back on from the year. And we wouldn't be doing that without the help of ShareFile by Citrix. Now, we're all familiar with the frustrations of bounce backs when you're emailing something that's too big to get through, when you're trying to send confidential files securely and you're not sure that that's going to happen, when you need a document and you're out of the office. But with ShareFile by Citrix, you don't have to worry about any of that anymore. It's the best way to send, share, and receive files of almost any size because it was designed for business. With ShareFile, every file stays under your control, so you know it's secure. You can manage who has access to any of the files that you send and how long they have that access. You can see when files are opened and by whom. Plus, ShareFile allows you to access files from any computer or mobile device. So it's an incredible tool in today's world where you're running around and you can't always have access to what's on your desktop. No matter what industry you're in, ShareFile can be customized for your company's specific needs. And that means you can both tweak its functionality and its appearance. For my own law practice, where I am a sole practitioner, I'm not going to go out and spend a lot of money to build an extranet for my clients to be able to interact with me and know that they're accessing the files that they need and they're going to get them and it's secure. But ShareFile lets me have a very professional presence in having that functionality with clients. So I really recommend it. I believe it'll benefit anyone working in the legal profession or any other profession. So you've got to try it. Don't just take my word for it. Go sign up with my special offer. You get a full 30-day free trial. Go to sharefile.com, click on the radio microphone, and enter TWiL, T-W-I-L. Remember, visit sharefile.com and type in TWiL. Thank you so much, ShareFile, for all your support in 2012. All right, so let us move on and see if we can glean any what not to do's from the Apple versus Samsung goings on this year. Let's talk about patents. It's patent time.
Quite fiery there, Denise.
Yes, incendiary patents. It's an incendiary topic. So I guess the takeaway here is even if you have a phenomenal victory, don't think you're going to get an injunction. Poor Apple. They could not have won more. But I guess, Nilay, I'll ask you, you've probably watched this closer than any of us. Does it matter? These products that they didn't enjoin aren't really a big sales issue for them anyway, are they?
So they made this hilarious argument to the judge that the Galaxy S2 is still being sold as a prepaid phone, and there's like 300,000 of them still in the market. And then, it doesn't matter. Judge Koh has basically ended every single hearing between Apple and Samsung, begging them to settle, begging them to stop wasting her resources and the court's resources. And they keep saying, well, we're willing to talk. They're just not willing to talk. And then she looks exasperated and like bangs the gavel and like goes home. There's no point. I mean, this injunction there's no point to it. The phones aren't in market. The next big, I think, for Apple is there's the Galaxy Nexus hearing, which has stock Android, and they can kind of do more with it. They've added in some other devices. But the old phones, in this case, like, who cares? I mean, Samsung has enjoined itself from selling the Galaxy Ace, right? Like,
right.
It's done. It's over.
Should Apple have even asked for an injunction here? Was it just a waste of everybody's time, money, and resources? I don't know. You ask for whatever you can get, right? I mean, if you're Morrison and Forster, sure, just bill the hours, right? I mean, imputing that to Apple, I think, is hard. But yeah, I think you ask for whatever you can get, and I think Apple is. I think they're negotiating in the courtroom, but they're also negotiating outside the courtroom. I think the HTC case here is pretty instructive. They fought and fought and fought. They had some decisions break either way, and they just settled like they should do. And I think Apple and Samsung, the business is so much bigger. They're the only two companies making serious profits. I think that process is going to be longer and a little bit more explosive. But eventually they will settle. And I think that these are just tactical ploys. If they can get an injunction on the Galaxy S2, they're going to walk right back in the conference room and say, the Galaxy S3 is next. And I think that's where they're headed with it. But man, I mean, these two, it's starting to break. I think Samsung is starting to lose the FRAND issue around the world a little bit. The FTC is kind of against it. They just withdrew the request for injunctions in Europe, and that was the biggest kind of arrow in the quiver were these standards essential patents for Samsung, and they're starting to lose. The brakes are starting to go Apple's way on those, and for pretty much every company that's involved in a FRAND lawsuit. So I think the government action there is going to start to change the balance, and I'm hoping they settle early into next year, because I have to say, between the actual lawsuit, which is exhausting and is now in the depths of procedure and demonstration, and then the terrible reporting that goes around, that we're constantly we're running the same story every 3 weeks for a different patent, basically. I can't wait for this to be over. It's this, the cycle is there's this period of rapid innovation and there's this period of rapid litigation, and then everybody pays each other and shuts up. And I'm hoping we get to the everybody is paid and shuts up and moves on point very fast. But then doesn't it just start all over again? I mean, this is not a situation where, we're talking about in the world of copyright, you think people have clued in and are selectively enforcing. It seems like in the world of patent, the opposite has happened.
Well, the individuals don't have patents. I think in copyright, it's different because it's inherent. For most, copyright is so consumer-facing and so user-facing. It's, how am I going to sell you a song? Because that's where the money is eventually. And we haven't seen. Have there been copyright battles between enterprise software vendors? Like, maybe. Does anybody care about them? No. The copyright battles happen in front of the user, so they've amended their behavior to sell a product because that's what they need to do to make the money. With the patent stuff, it's the patents enable you to make a user product. And I would argue that the patent lawsuits have not affected the user situation at all. Like, there might be some pricing adjustment that's pretty invisible to people. The phones are free and $99, so it's not a big deal. But ultimately, it's just Apple and Samsung spending money so that they can eventually pay each other. And the rapid innovation this past year alone, I think has completely proven the point that the patent system is broken in some ways, but this idea that it's like devastatingly killing innovation, I don't know. Apple released like 15 devices, Samsung 1,500 devices. They're Samsung, so it's not slowing them down. They just really need. Those two in particular, I think once that lawsuit settles, I think the rest will quickly fall in line. I think the world is waiting to see how that plays out. And, if Apple and Samsung can settle their dispute, I think the judge will look at Microsoft and Motorola and say, come on, like the big boys figured it out. Why can't you? And they'll get there.
Well, I guess Microsoft and Apple come to mind as a big copyright dispute over the UI, but that certainly wasn't in 2012.
And Google and Oracle. I mean, there was the API issue just this past year. That was a copyright issue, but there were obviously patent issues in that as well.
Right.
And the Oracle SAP lawsuit, which was principally a trespass to chattels claim, but had copyright to it. But, it's easy to say that Apple and Samsung all work this out, so there's not a chilling effect from patents. But, those are the big incumbent players. It's the small startups, I think, that are much more troubled by their risk to patent lawsuits. And they can't go out and buy, a $500 million Kodak patent portfolio just in case it might help. Just on the off chance that someone might have bought them and sued us with those patents. And so those are the people I'm worried about.
The Kodak thing is actually really interesting, and I think that the structure of the Kodak sale, I think actually reflects the new reality, which is that Apple and Google and Samsung, all the big players, are very tired of patent lawsuits, and so Kodak sold their portfolio for $525 million. They sold it to a consortium of intellectual ventures in RPX. So they sold it to a consortium of consortiums. And how more dilute of ownership can you get? RPX has promised to never litigate anything. I think they're just trying to get this stuff off the market. They're just paying to put Kodak in a box and never talk about it again. And I think that's where they're headed. I think they would much rather. I think Apple and Google talk a lot, and I think Samsung and Apple talk a lot. And I think they would all much rather put this behind them and move on because it hasn't, it hasn't affected their ability to directly compete. And as much as Apple would like to believe that they invented all this stuff and they have a right to it, and I think they forced Google to implement some really serious workarounds, which I think are good for the industry. I think it's good that Google can just copy iPhone, but that's been accomplished. I think if Apple's smart, they'll recognize that Android is on a very different path than iOS, regardless, and they've accomplished their goal of putting separation between the products.
Professor Goldman, last month at Santa Clara University, you guys had quite a patent summit. Were there any what not to do's from 2012 that you could sort of extrapolate from the discussions there?
We actually, one of the hashtags that evolved organically was the patent prom. And in fact, we had it in a room that's used by students, and there is literally a disco ball in the room that can turn on and swirl when they throw their proms there. The conference that we had was a little bit different than most conferences. We didn't go in with the idea of debating the issue. We didn't go in with trying to teach litigators how to tear each other up more smartly. We went in with the premise of saying we want to get people really invested in this topic in the topic of software patents to think, how can we solve whatever problems we're experiencing with software patents? And different people might assess the problem differently. Some might say it's catastrophic. Some might say it's just a blip in the road. But whatever the problem was, we had over 24 different ideas come out to discuss to evaluate how can we fix the problems with software patents. So we didn't get a what not to do lesson from that, but we did get a number of, I think, helpful, thoughtful suggestions about ways that we could, I think, better channel software patenting behavior into socially productive activities. And I'm happy to go through that in more detail if you want. I did write up a blog post laying out my favorite ideas from the conference. And there were a lot of them. So do you tell me if you want to get into the next layer of detail?
Well, I mean, is there I know it's a complicated subject, and I know that the short answer is probably we don't want software patents to be more extensive and prolific than they already are. But is there a bit more detail we can add to that?
But I mean, there's so many different ways of addressing the problem. Some of my favorite ideas were to focus on the way that software patents are claimed. Mark Lemley at Stanford put out the argument that right now people are patenting the problem, not patenting their solution to the problem. And so he just suggests a simple thing. Let's just rejigger it so that we require the patent applicants to only get patents for the solution to the problem, not to the statement of the problem. And that would take care of a huge chunk of the software patent problem right away just by doing something like that. There are some market-based solutions. For example, two professors at UC Berkeley are working on what's called the defensive patent license. Basically, it's a network effects approach to disarming patents. Anyone who signs up for the defensive patent license agrees not to enforce their patents against everyone else who signs up for the license. So basically, it's a way of changing the payoffs from what's currently a prisoner's dilemma. Instead of everyone fighting with each other and finding it in their best interest to do so, it's in their best interest of everyone participating in that license to cooperate with each other, to basically defang their patents. And so I'm very interested to see what kind of marketplace response we'll get from that. It's an example of how we don't necessarily need any change in the law. We might be able to have the industry solve some of the problem itself. And one last thought I'll throw out. There was a bunch of discussion about the ways that we handle patent maintenance fees. The idea is that in order to retain your patent, you have to pay the government some ongoing payments. And we could simply jigger with the way that those payments are computed and the timing of those payments and potentially get some really big and useful results from that. So there's a whole list of things that we might do, some of which don't necessarily even require changes to the law. They might just be the way we think about the law and execute on it.
All right. Well, we really appreciate that recap. I know it was a wonderful event. Do you think you'll do it again on a fairly regular basis? Because it seems like bringing all those minds together to hack this problem is a good thing.
It really is. And one of the ways we approach our conferences is we want to create, obviously, some topic for the conference. But then usually we let the speakers organically bubble up the most interesting things on their mind rather than saying, I want you to speak about this and not that. So that was an example here. We said, here's what we're looking for. What's your idea? And it bubbled up from the bottom from each of these speakers, which unique vector of attack they wanted to explore. This was actually the second of a series that we've had on patents. In 2011, we had a conference on how to rethink managing your exposure to patent lawsuits in the new environment. Part of the new environment just being the emergence of NPEs, PAEs, trolls, whatever you want to call them. And then we followed it up with this conference, how we're going to attack software patents. And we have some skunk works to discuss a possible event to complete the troika of patent-related conferences, but that one's still in process, and I'm going to have to actually defer the discussion on that one a bit.
Okay. Evan, anything you want to add to the patent discussion before we move on?
apart from just saying that that's a great thing that you're doing, Professor Goldman, playing such an instrumental role in getting smart people together to talk about that. So I commend your efforts for that you've taken on now in this year. So good work, and everyone benefits from it.
Thank you very much.
All right, well, let's look back at what Washington might learn not to do from 2012 on the policy front.
Got the porn music there, Denise.
Yep, there we go. That's our Sanford and Son bumper. Hey, yes, Sanford and Son or porn. Let's hope we don't get sued over either of those. So, of course, a huge year for keeping your hands off the net. Just coming off Wicket, which was a big debacle for anyone who thought that they were going to add a whole lot of control over the internet to the proceedings. That certainly didn't happen. The U.S. and how many other countries? 55 other countries, something like that, walked out. Did not sign on to the proposed agreement because of concerns very eloquently stated by FCC Chairman Julius Genachowski that what was going on there was going to be damaging to the internet and the innovations and economic benefits that it can confer. And of course, there was a little thing called SOPA, which didn't go very far, SOPA or PIPA, or any of their progeny. So is our what not to do then hands off the net, or just don't over-regulate the net? What do you think, Professor Goldman?
Well, it's interesting because the U.S. government was in a key part of pushing SOPA, but then went and scuttled the effort at the ITU convention about efforts of other governments to try and regulate the internet. So I think we're still trying to figure out even our own national standards for when it's okay to put pause on the internet and when it's not okay. And I'm not even sure the Obama administration is internally consistent about that. I do think that the lesson from SOPA, there are multiple ones, but the biggest lesson I got from SOPA is that we're pretty passive as a society about the abuses of our government. We just kind of shrug our shoulders for most of them and take it. But if anything looks like a threat to the internet, that's something we as individual users will grab the pitchforks and go and try and fight the government to prevent. And I was really heartened to see that. The internet's become such an integral part of our lives that it's worth fighting for. That's how I feel, and I think I was not the only one. I don't know what happened in Dubai. I do not understand the process. I do not understand diplomatic procedures. I do not have the personality to hang out with those people. And so it was all mysterious to me. I think it would be a mistake, though, to think that we have a world today where governments have paused off the internet. I just don't think that's the reality here in the United States, and I know that's not the reality elsewhere. And in fact, I have a coming blog post about how I think it's time for us to just retire the term "the internet." You remember George Bush's mistake referring to the internets, but that's exactly what we really have today. We have a bunch of internets that are each harmonized, customized for the local country's laws and culture. And in some cases, the local government can literally turn off their internet. Syria can just say, there is no Syria internet today, but you can still have your United States internet. Good luck and God bless. And so, I'm not sure I totally agree with your starting point about the pause off the internet approach here. I think we have we have a lot of duality about that among our government, and I think, frankly, among each and every one of us. Most of us subscribe to the view, pause off my internet, but there's just one thing I wish the government would fix.
Right. Yes, that's why I gave myself some wiggle room there on whether it should be regulated or just not over-regulated. Nilay, we won't read terms of service, but we don't want people messing with our photos, and we don't want people messing with our internet, apparently.
Well, it's funny because the question is, what are you messing with? I think the biggest problem with SOPA was this idea that the government would monkey with DNS in some way, which is just the wrong solution. I mean, it's funny too, because I think people's understanding of the internet is that it's everywhere and it exists outside of states and governments and physical location. And this, SOPA was Fortress America. It was, if we don't like this server in Russia, we will delete it from our DNS records and you'll never get it. And that doesn't seem like the right solution. Like, that is a technical solution to a behavioral problem and a legal problem. But at the same time, it's, our readers were very happy that the United States went to the ITU and said to Russia, we're not taking your proposal. In that sense, the government is participating directly in the regulation of the internet by saying we're going to stay in charge of regulating the internet. So it's this balance. I think I got a lot of questions this year about why is the government so interested in the internet all of a sudden? Why every day is it, if it's not SOPA, it's CISPA. If it's not CISPA, it's like, there's this COPPA reforms that just went through. COPPA, that's one of those words I never say out loud, that just went through.
Right.
It's this endless drive to, like, the government is like looking at what we're doing on the internet and they're talking about it. And the government is thinking about you late at night and what you're doing on the internet, and it wants to do something about it. And it's just, that's where the people are, and that's where the money is, and that's where our society has moved. And the government's coming. I mean, it will naturally follow the will of the people and the actions of the people. The question is, and I think this goes to what the professor's saying, is right now, the way our internet's structured, the companies who are making the most money off of it are very happy with it. And it might not be the best way for the internet to be structured, but for Google it is. Right? Google optimized its business to make a ton of money from this current structure of the internet. So they're lobbying heavily and saying anything you do will ruin our freedom on the internet, will ruin user freedom on the internet. And I think the question for us is user freedom so tied up in, is it intertwined inextricably from the things that are good for Google's business? Google's lobby is very strong, and that's the way the internet feels to a lot of people. But I don't know that is necessarily a permanent truism. And I think that we should actually talk about what we would want the internet to look like, aside from Google going dark and Wikipedia going dark and all these other sites going dark, because their interests are not necessarily the broad interests of the internet population.
Yeah, excellent point. And you've inspired me to make our second MCLE passphrase of this episode of This Week in Law, Big Brother. So write that one down if you're going to seek MCLE credit for the show. And if you're wondering how you might do that, head on over to our wiki, and the details are there on a state-by-state basis. Hey guys, this has just flown by, but I think it's time to give our last resource and tip of the week for 2012. Our resource comes from Mashable, and it's actually forward-looking to 2013, to the world of augmented reality and Google Glass. And I'm seeing from this article here that Nokia has something in that, the Nokia City Lens, and how advertising is going to work. And it goes right along with the discussion that we've had here today about how our notions of advertising and disclosure are maybe not sitting well with the way that technology, and we've been discussing social networks, but gosh, it's going to get interesting when we've got these virtual reality apps in our lives. And there's a great article over at Mashable called Navigating the Legal Pitfalls of Augmented Reality. It's by Alyssa Hutnick at Kelly Dry, big law firm, and she has some very good practical things to think about if you are going to unlock AR's full potential, as she puts it. She discusses disclosing privacy practices, how you should best obtain user consent. Of course, that's a big, hairy issue. Create a plan at the outset to limit the privacy issues, and be very careful with children and how you treat their data. So go over to Mashable and check this out to get all the details on the legal pitfalls of augmented reality. And then our tip of the week, I was listening to TWiT last week where they mentioned Snapchat And last night I was at a holiday party with a bunch of friends who have older children, all teenagers, and they tell me that Snapchat is the thing. It's what all their teen kids are using. I don't know that that's necessarily a good thing, but that they're all off Facebook and using this tool. Well, over at the Not So Private Parts, Cash Hill has written about why using Snapchat is not a good way to guarantee your privacy. And she has run down that in some detail and tells you why you think these self-destructing photos are keeping you safe. That's not really the case. So our tip is don't think that you're going to use Snapchat and have a good spotless reputation thereafter, because the way that the app works doesn't really lend itself to that. Are you guys seeing a lot of Snapchat in the wild, or are we just too old for this app to really be affecting us? What do you think, Evan?
I don't even watch Gangnam Style, so I'm not the guy to ask.
I haven't. I haven't used it. I haven't seen it.
It's enough of a phenomenon that Facebook, like minutes ago, announced a competitor called Poke.
Did they really?
Like literally, we just broke. That's why I've been distracted in typing. We just broke the news on our site. Poke by Facebook is out. It's a Snapchat clone. I mean,
wow.
it's a phenomenon. You know, look, this all goes back. You know, this comes all the way back to terms of service and what expectations do we have on the internet. And people want to be, teenagers in particularly, want to be able to say dumb things to each other without a permanent record. And I think that in the crocodile brains of every teenager, they understand that they're stupid and that they shouldn't make permanent records of their behavior. And that Snapchat feeds that demand, and it's a huge demand. And the internet isn't built, as far as I understand it, my entire life, the internet is not built to delete anything. It's still there. You can find it somehow. Right. And that doesn't match up with our behavior. So it's not,
well, there's the answer to your earlier question. Is there a market for privacy? Apparently so.
Yeah. Somebody just immediately tweeted, teenagers want to be able to say dumb things to each other without a permanent record. I hope that's my quote of the day, apparently.
Yes. And it's a truism. It's definitely the case. But I bet that Poke is going to suffer from all of the same pitfalls, or perhaps some of them, that Snapchat does, that Cash Hill has run down here in her piece. So go check that out, and be careful whenever you're throwing selfies around the web. Evan?
I'm sorry, throwing what was that?
Selfies. Yes. This wasn't, I can't pretend that I'm terribly familiar with that term either, but apparently that's the picture that you take of yourself in the mirror with your cell phone. Clothed or otherwise.
Good to know.
Self-portrait. Evan, it's been an awesome year. Thank you so much for being here the whole way. This has been a really fun show. I think we've learned a lot.
It has. Thank you. It has been a great year, and 2013 promises to have even more. You know, it's already December 22nd, 2012, somewhere in the world. So I guess we've survived. So yeah, awesome show.
Hooray.
Great talk. Yeah, great talking to you, Professor Goldman, Nilay. Always great talking with you.
Yeah.
So happy holidays, everyone. Merry Christmas.
Yeah, happy holidays, you guys.
I
I can't think of a better way to wrap up our year than having you two on the show. And Nilay, you're the best multitasker I've ever encountered, because no, you don't seem distracted, and yet you're editing stories for The Verge as we speak. So it's been wonderful getting a bit of your time.
I always feel like I learn so much when I come on the show, and I like how the light is doing this thing to my face now. That's terrifying. No, I always feel like I learn so much coming on the show, and I love hanging out with you and Evan and Professor Goldman. Really nice to meet you, actually.
Nice to meet you too.
I've been reading your stuff for years, so it's been an honor and a pleasure.
Yeah,
My pleasure.
I think they've just nature has provided you with a bit of holiday lighting for the end of the show there.
Yeah. It looks like lasers are burning my face off. Holiday lighting is like the aliens have come to destroy me, and that's what's happening.
That's right.
Goodbye.
The final rays.
The light now.
The final rays of sun on the shortest day of the year are hitting you right now. So Thanks so much, guys. And we will be back on January 11th. We're going to be on a break until then. We hope you all enjoy your holidays. If you are jonesing for back episodes of Twill, of course, you can find them at twit.tv/Twill and over on YouTube as well and in iTunes. Please visit with us on our Facebook page and Google Plus pages. I haven't yet set up a Google Plus community for This Week in Law. I haven't decided if I'm going to do that yet or if we should do that. So if you have opinions on that, let me know. Maybe we should have one. A page, a community, I can't really tell the difference or see why there would be much difference, but maybe there's a good reason to do it. So happy to hear your thoughts on that. I'm Denise at twit.tv. Evan is Evan at twit.tv. And we're just honored and thrilled to be able to come here every week and discuss these kinds of issues with you because they're important and they affect all of us. And we hope that you've learned something from our What Not to Do episode of This Week in Law. Thanks, everyone, for tuning in.